good afternoon, everybody. Looks like we're starting a little bit late, but I think it's going to be worth it. So I see a lot of veterans in the industry. Who here has been practicing real estate for 10 years? Okay, a lot of people. What about 20 years? What about 30 years? What about 40 years? No? Yeah? All right. Who here is familiar with partition actions? Partition actions. No. Okay. So a lot of you are a little bit. All right. You ever done one? No. Okay. Well, then I'm really excited that I get to share with so many of you veterans something that has probably been in your lives over and over and over and over and over again, and you just didn't know how to deal with it. And this is a great opportunity for all of you. So, the first thing that I want to share with you is I'm one of you. I'm a licensed real estate broker. I'm a real estate investor. I went to school at Hastings. Well, it used to be called Hastings in San Francisco. Now it's called UCSF Law or something. I don't know. Hastings got canceled. Anyways, I went to school in San Francisco, and I've been an attorney for about 15 years. I have a firm. We have about 9 members. We have 4 offices. We have an office in Oakland, Sacramento, LA, and Newport. We have 4 other attorneys besides me. And all that my firm does is handle partition actions. Okay. So we just do this one thing all over the state. That's it. Right. So what is a partition action? Some of you are definitely wondering at this point, right? The first thing to know is it's not lot splits. Not here to talk about lot splits. Apparently you can split a lot. That's not that interesting. I don't think that's all you need to know about that. So we're not here to talk about that. Okay. So what are we here to talk about? It's another type of real estate sale. So for those of you who have done short sales, for those of you who have done REO sales, for those of you who have done probate sales or divorce sales, a partition action is just the last tool in your toolbox that you need. It's just the last one in that series, right? And so for you veterans of the industry, I'm guessing that how you got through what we'll call the bad times, the downturn, was you learned how to do some unconventional sales, right? Everything is not always going to be 2020 or 2021 where everything just flies, all the houses just fly off the shelves, right? Sometimes you experience, I don't know, low volume, right? Not a lot of people want to list their house. Does that sound familiar? Okay. Well, so let's talk about some other ways that you can close leads when there's low volume or in more challenging environments. Something called a partition action. It's a legal process of facilitating the sale when you have 2 owners of real estate. One wants to sell, the other one doesn't. One or more want to sell, or one wants to sell, but other people don't. That's what it is, right? But without getting too much into the legal jargon, I think the best thing to do right now is just to give you some real world examples, right? We'll kind of bring it down to an everyday level and what you experience as realtors out in the field. So, shake your head if you've heard this story before. Boyfriend, girlfriend buy a house together. Oh, yeah. Maybe you sold them that house, right? And they buy this house because they think they're going to end up happily ever after. But then they don't. He meets somebody else. She moves in with her mom. New girlfriend moves in, right? And now, all of a sudden, she owns a house with her ex-boyfriend that she doesn't get to use, right? That she's on the hook for the mortgage for. And it's a terrible situation, right? And so she goes to her ex and says, listen, I want to, maybe they bought a starter home in, I don't know, East Palo Alto, right? And she says, I'd really like to get out. And he says, it's not a good time for me. Interest rates are high. Prices have run up a lot in the last 4 years, especially in East Palo Alto, right? I'm good. No, thank you. Right? You want to sell? No, thank you. Right? And she is now in a situation that I like to call hell, right? She is stuck. She cannot sell it with a realtor because in order to sell that property, you have to have the signatures of all the owners, right? And she can't get her ex to list it. So she is stuck, right? She is trapped in this ownership of this house, right? And this is a problem. Even if our ex-boyfriend continues to pay the mortgage, right, every month, it doesn't affect her credit. She can't buy another house, right? Because she's not going to qualify, right? Because she's still listed on the mortgage, and that lender is going to say, nope, sorry, it looks like you own this house, and you don't qualify for another mortgage. She says, well, but my ex pays for it, and there's just like, that's too bad, right? That lender is going to decline that every single time, right? Because her profile is not right. So she can't move forward, right? She can't get ex-boyfriend to sell. What does she do? I don't know. How does she get out of this trap, right? So let's talk about another scenario. Tell me if you've heard this story before. Two brothers, very similar, some might call them twins, inherit mom and dad's house in San Francisco. One brother, very successful. He's a world beater, succeeds whatever he does, right? Moves to LA, gets into movies, life takes off, right? Our other brother, not so much, right? He can never quite get his act together, can't hold down a job, right? Maybe he has some run-ins with the law, probably has an ex-wife or some kids in there, right? He's just never life just doesn't seem to work out for him until he inherits mom and dad's house in the Presidio. And life is great. He's got this $5 million house in the Presidio. Things couldn't be better, right? It's all working out for him, right? And so what happens is our brother number one comes to you and says, hey, listen, I got this house in the Presidio. I'd like to list it. And you say, that's great. Let's list it today. Let's get that on the market. It'll fly right off the shelf. And he says, well, the thing is, I got this other brother and he doesn't want to sell, and it's a problem, right? Even if that house is fully paid off, so we don't have the mortgage problem we had with our ex-boyfriend or girlfriend, somebody's got to pay the taxes. Somebody's got to pay the insurance. Let's say, the roof isn't in great shape after mom and dad not taking care of it for 20 years, right? Who's going to pay for that roof to get repaired, right? Let's say brother number two likes to, I don't know, throw wild parties. Somebody gets injured on that property. Who's liable? Well, brother number two, of course, but also brother number one, right? So again, brother number one is stuck, right? Brother number two doesn't want to sell. Brother number one does. Okay. Let's talk about a third scenario. You got two friends. They have a great idea. They are going to buy an Airbnb together in Tahoe, right? And they are going to list it out, right? And they go and they scope out this perfect Airbnb because they love to, go snowboarding in the winter. And they're like, oh yeah, we're going to go snowboarding. We'll Airbnb it. We're all going to make money. It's going to be great. And then after a while, they stop getting along, right? They are no longer on the same page and arguments ensue, right? One wants to use it on the same weekend as the other. One doesn't keep it up as much as the other one does. Maybe every house on the block in Tahoe is now an Airbnb, so they're not making the money they used to, right? And once again, one wants to buy, but the other one doesn't, or wants to sell, and the other one doesn't. So what happens? They come and talk to one of you. Come and talk to a realtor. And they say, hey, listen, I got the starter home in East Palo Alto, mom and dad's house, the Presidio, this Airbnb in Lake Tahoe. Can you help me? And you guys say, that sounds hard. I wish you could figure that out. Why don't you come talk to me once you talk to your ex-boyfriend or brother number two, or your idiot friend, your idiot snow friend, snow buddy that you like goes skiboarding with or snowboarding with, and come back and we'll figure it out. And they say it sounds good, and then you never talk to that person ever again, right? They are gone. That fish has swum completely out of your net, never to be heard from again, right? But what if I was to tell you there was a way to get all those houses listed for sale? Might be kind of interesting. Something called a partition action. What is a partition action? A partition action is a lawsuit that basically has 4 steps. File a lawsuit. The other party has the right to buy out the first party at an appraised price. If they can't, property is listed for sale. Once it's sold, proceeds are distributed, right? That's it. The lawsuit for a partition action only has 3 parts. 1, you own real estate. 2, you no longer wish to own that real estate. And 3, that's it. There's only 2. So there's not a third thing. It's just you own real estate and you no longer wish to. That is all that's required. You don't have to allege they breached a contract, they committed fraud, or they were none of that. It's just, I own this thing and I don't want to own it anymore. I don't get along with this person. My ex-boyfriend and I don't see eye to eye. My brother and I just have never gotten along. Whatever it is, right? The law doesn't care. Just says you own it, you don't want to own it, let's sell it, right? And our ex-boyfriend, who couldn't afford to buy that house at 8% in East Palo Alto, especially when they bought it for, I don't know, $400,000 back in 2018 when they got together, is definitely not going to be able to list it now and buy out the other person's interest now. Now the interest rates are 8%, right? Brother number 2 is not qualifying for that mortgage for mom and dad's house, right? Your idiot snowboarding friend probably doesn't have his financial act together. So what happens? Houses get listed for sale. So what I do is I get realtors appointed to sell real estate. So these are orders signed by judges, sell real estate. Okay? That's what I do. So some of you are probably saying, well, Eli, it can't be this simple. Everybody knows that you lawyers, you make your money from arguing. You make your money from making things complicated. Well, okay, there is one known defense in California, just one, to a partition action, something called a waiver of the right to partition. So if our ex-boyfriend and girlfriend, if our 2 brothers, if our idiot ski bum friends talked about a waiver right to partition, then yeah, you could probably stop that lawsuit, right? But let's be honest, our boyfriend and girlfriend are talking about a lot of things. They're definitely not talking about a waiver of the right to partition. Our idiot brother number 2 doesn't have waiver right to partition on his mind, right? So from my experience, these things are relatively rare, okay? And what's interesting about a partition is that if it is real estate in California, you can partition it. So right now, I am partitioning single-family homes in San Francisco, but also warehouses in San Jose, also apartment buildings in San Mateo, right? If it is real estate, you can partition it, and you do not need to be a 51% owner or a 50% owner. I filed a partition action when my client was a 4% owner of an apartment building. Now, why would you file a lawsuit over 4%? Well, I guess the question is, do you think the 96% owner was going to pay that 4% owner 4% of the value? Because if you do, they weren't. They were not, right? They said, listen, your interest is basically valueless, so why don't you just give it to us for free, right? Or something approximating that, right? And so what a partition does is introduces fairness into the equation. It just says, listen, just let me out of this relationship, right? Just let me move on. So if it is real estate, you can't partition it. So again, those of you who are veterans of real estate, you've probably had your entanglements with the law or heard of lawsuits, and you know that you generally cannot recover your attorney's fees unless there's a provision in the contract that provides for it, right? Or a statute. So what's interesting about the partition law is there is an attorney's fee statute, which is very useful, right? Because it allows my clients to recover their attorney's fees when I run into some lawyer who's loves to be difficult because that's what he always does, right? And so I've gotten awards for 60, 70, 80% of my clients' attorney's fees, right? Which effectively makes it, you know, not free for my clients, but effectively free, right? Pretty good deal. And so what's interesting is doing this as much as we do, I run into all sorts of lawyers. You know, I'll run into your grizzled veteran. I'll file a partition and I'll say, oh, partitions. I've done probably 7 of these in the last 10 years. I say, wow, 7 in 10 years. That's cool. We're handling over 100 right now. It's like 100? I said, right now. That's not even possible. I said, well, we're doing it, right? This is all we do, right? And just like lawyers, realtors, you can do a lot with your license, right? You can sell, you know, single family homes in San Jose. You could also, I mean, you could sell office buildings in San Francisco. You could lease commercial space in Oakland, right? You could sell farmland in Stockton if you wanted to, right? With your real estate license. But let's be honest, probably not going to be the best at it. But for some reason, lawyers are just geniuses and they think they can do everything, right? I know I'm not that smart. So I just do one thing, right? So all we do are partitions. So we do not handle HOA disputes or construction defect litigation or tree fell on my yard or realtor negligence. We just don't do it. Turn it all away, right? We just do this one thing. Why? I don't know. Wouldn't you want somebody who's been there before, who actually knows what they're doing, right? And so why does this matter for all of you, right? For each of you. And I guess the thing is, if you've encountered, you know, our ex-girlfriend, our brother number 1, right? One of our ski bum friends, right? You've probably turned these people away. But if you were the realtor who had this knowledge, not only could you potentially close that sale, you'd be known as the trusted resource for real estate issues, because everybody knows there's a real estate issue. They go speak, everybody goes to speak to a couple of different realtors. What do you think my house could list for, right? What's the market doing right now? You know, what's happening with the industry, right? Talk to several people. Most of them have no idea this exists, right? I was at CAR 3 weeks ago in Anaheim. I spoke to over 200 realtors, right? People with 10, 20, 30, 40 years experience. Only one of them knew what a partition was, right? Which is one of the reasons why I got myself appointed by CAR to teach partitions. So I am the CAR instructor on partitions. And so for you who know about this information, have access to this tool in your toolbox, you can stand out from the crowd, right? So this is my team. Our office is in Oakland. That's my contact information. We'll be adding another attorney shortly to our Southern California office. If you want more resources, I can go back if you want. If you want more resources, here's a post on our blog, 10 things every realtor needs to know about partitions. It's at underwood.law. And now, for the moment you've been waiting for, we get to play Quiz the Lawyer, everyone's favorite part of the program. So I'm happy to answer any questions you may have. Yes.
Okay, 2 questions. How much? And typically, what's the average?
Yeah.
And how long does it usually take?
Yeah. So, can you hear me okay?
Yep.
Okay.
I just need this for Zoom.
Okay. Do you want me to repeat the question?
If you could repeat those questions, and if they have questions on Zoom, I'll ask them.
Cool. Right on. Okay. So, the first question was how much, and the second question was how long, right? So, good questions. So, number one, many simple partition actions, $5,000 to $15,000, right? Obviously, it could be less. I filed partitions. The other side says, you want the house? Fine. Here's the deed. Lawsuit ends right away, right? Or let's not mess around with the lawyers. Let's just sell it. Didn't realize you could do this because they got some bad advice from somebody who doesn't know what they're talking about, right? Lawsuit ends quickly. Sometimes you do get, the grizzled veteran who just loves to fight. And then he has to explain to his client at the end why they're paying our attorney's fees in what I imagine to be a very awkward conversation. So I don't like awkward conversations. So I prefer not to have them, right? But other lawyers might, and that's between them and their clients, right? How long? Well, the problem with that question is you didn't give me the two most important pieces of information, which is number one, who's doing it? Is it somebody who knows what they're doing, like an experienced partition lawyer?
You.
Oh, me? Well, and the second most important piece of information is where is that real estate? So Santa Clara County, for those of you who have been engaged in the legal system here, may know, insanely slow. Santa Clara County, honestly, one of the slowest in the entire state of California. And I practice from San Diego to Shasta counties. Santa Clara, one of the slowest, one of the hardest to process things. San Francisco, pretty good. Alameda, pretty good. Solano, pretty good. Contra Costa, not bad. Not bad. San Mateo, not bad. Santa Cruz, pretty good. Monterey, pretty good, right? So I typically put these at 3 to 6 months in many simple partitions, but I'll advise the client, we may be looking at something of like up to a year, right? So it really just depends on where the property is located, and some of the other issues involved. But those are very good questions. Yeah. Anyone else? Yes.
Well, for starters, the 3 to 6 months is outside Santa Clara County, so 16 months to a year for Santa Clara County.
Probably 6 months to a year for Santa Clara County. Yeah.
And
So we do not handle family law. So we only handle unmarried couples, right? So our boyfriend, girlfriend, right, who did not buy a house together. We do not do family law. Generally family law is, it's much more complicated, right? There's alimony or child support or a number of other issues. So but that said, it's an interesting question because I have a number of people right now who got married, bought real estate, got divorced, but they still own real estate together. So they have the privilege of going through the legal system twice. So you can partition property owned by formerly married couples. And we are currently handling a number of those in, San Joaquin, Alameda, Contra Costa, up here. It's just not something like I just don't feel like I have a advantage in the family law sphere. So I'm just like, if the people who want to do family law, that's cool. But here's what's kind of interesting about that is, and some of you may have noticed this, people aren't getting married anymore. Statistically, people are not getting married anymore. In 1980, the numbers were that people of a marriageable age, defined as between 20 and 40 years old, about 85% of those people were married in the population, right? 2023, it's less than 50%, right? So for whatever reason, whatever it is, people are just not getting married anymore, but they understand the value of home ownership. They're buying houses together. So they're finding themselves in this situation where boyfriend, girlfriend, buy a house together, break up. And now they're like, how do I get divorced without getting married? Kind of a funny problem to have, but it's happening. So, no, I do not handle currently married people. I just don't think it's something that we would do in a superior way to other attorneys, the way that I feel like we offer superior service as partition lawyers. Yeah. Yes, you, sir.
So I'm sorry, I missed the cost piece of this. I think you mentioned timeframe, but did I miss how much you said it was gonna cost?
5 to 15.
So yeah, somebody asked, yeah, how much in many simple partitions, 5 to 15, it can be more, it can be less, but that's kind of what I look at as a ballpark. Yeah. Yes, ma'am.
Show the cost. Well, the cost, is it also based on the value of the property and the complication of the process?
So that number is not, that's just kind of my ballpark for, a simple partition. So yeah, unlike a realtor, I don't just say, 1% or 2%. I don't work that way. We generally work on an hourly basis. We do offer, to do some work on contingency basis in the right instances. But it's basically just an hourly. So whatever's required for the job, we just do that.
So the amount is less, I mean, the clients will have to pay you a lot of money and not getting that much.
Well, so it depends, right? So what if our starter home in East Palo Alto has, I don't know, $500,000 in equity, right? Let's just say, right? Okay. So let's say it's $30,000, right? It's towards the higher end. So, okay. So you're saying if you give me $30,000 and I give you $250,000, that's a bad deal? I mean, it's not great. I don't think they're thrilled about that, but they haven't been cheated or like given it's not a bad business decision, I guess is the way I think about it. That's a good business decision. It may suck, but
The lawyers usually try to extend the time so that they get paid a lot of money.
I mean, that's a discussion between those lawyers and their God. And I don't know, we generally do these as fast as legally possible in the state of California. So our goal is to get them done as quickly as possible. But yes, ma'am. I mean, it's a transfer that we like to, we would wrap it up and complete the process. I mean, I guess, honestly, it's rarer. It's incredibly rare for somebody to just say, okay, here's the house, right? Here's my half of the house. Those are more unique situations. So in those instances, I don't know, it depends on what the homeowner wants to do. I think, what I've seen is homeowners say they wanted to get it sold because of another factor, such as my kid's going off to college in a year. I don't know how I'm going to fund this, own this house with my sister, kind of like to just, get that money, whatever it is, $250,000, $500,000, fund that kid's college education fund, take off some of the financial pressure from me and my wife. Right. Or, I'm getting ready to retire and, the market's been tough, kind of want to list that house. Cause like, I just, I'm not living in it and the rental value and it needs some repairs and I don't want to invest any money in it. So I'd rather just get rid of it. So, I mean, do I know what happens in those instances? Honestly, I don't, but generally that's the sort of logic that leads people to calling me in the first place. Yeah.
I've got 2 questions on Zoom, so I want to do that and then we'll get back to in
Yes.
person. The first one is, would partitions between parents and children be considered family law as well? And do you take those types of cases?
So, one of the more interesting flavors of partition, mom and dad suing the kid and kid suing mom and dad happens. We handle them. It's unfortunate. And they're definitely less common, but we do help. I mean, look, my fundamental belief is in just kind of letting people move on with their lives and make their own decisions. And if they're trapped, then I kind of want to help them get free and just do whatever they want as a, kind of as a general philosophy. So we do help people in those situations. Yeah,
All right, one more on Zoom.
sure.
Will the judge in a partition action eventually order the co-owner or tenant out of the property, or does the plaintiff have to go and then get an eviction attorney?
So, very good question. Let's see. Can you see my screen? Yeah. So you go to a blog. So, in a partition action, following a judgment, you can get something called a writ of possession, which is what are provided in the analog of landlord-tenant cases. And so we are engaged in removing uncooperative co-owners from their homes right now. So yes, we do evict co-owners, so to speak, through a writ of possession. Yes, I think you had a question.
Yeah, I have a couple. Is it okay?
Fire, hey, you get to play quiz the lawyer, so here we go.
Make it real simple. Flat fee, you guys do flat fees.
We have in the right circumstances.
We even know upfront how much it's gonna cost.
In the right circumstances. Yeah, I need to talk to the owner about the situation and what's involved. And we'll talk about that, right? So there is this defensive waiver, right? And there's a couple ways that courts have interpreted that, right? And just like if you're a client, you don't want to sign up a lawyer who's not going to be able to get you there. I also don't want to sign up clients who I don't feel like are going to be successful, right? If I think, man, you're going to run into a buzzsaw, I just want to take the case, right? Because like, why would I take their money just to get them somewhere they're going to be pissed at and it doesn't work for them, right? So I, have to talk to the owner in advance about, okay, what are the issues? What's going on? Let's talk through this concern. So I counsel the client in advance. Yeah.
And then get back to that family thing. I just want to make sure I understand that. How about partition actions between brothers, sisters, cousins, or if there's a legal domestic partnership? Do you guys take care of that?
Yeah, so we handle all those. Legal domestic partnership is interesting. I mean, I really haven't I haven't seen that, like, really that being an issue since gay marriage was legalized back in 2009. So it's just less common. But generally the family code only applies to, family, which is married couples. Yeah. Well, the family code doesn't apply to brothers, sisters. So we handle lots of brothers and sisters, lots of cousins, right? Lots of, great aunt, Martha owned this house and never had any kids. And now the, 8 of us own it or whatever. Right. But one, just refuses to sell because he gets to live for free in Santa Cruz or something. I don't know.
Okay, two just simple ones here.
Yeah.
Do you have to file in the Mitchell St. Clair County, you want to slow us? Well, so I have a property in St. Clair County. Can I file that partition action in San Mateo County?
No, unless so if the parties own several pieces of real estate together, and this is something that we're doing right now, if they own several pieces of real estate and you want to partition several different parcels. So for example, I have a client who inherited with his siblings some real estate in Chico, but also in LA, right? So, you could file either in Chico or LA. So instead of doing 2 separate lawsuits, the law is you can just file in Chico. So we just filed in Chico. Yeah.
And then last question. Okay.
Sure.
How does the judge determine who gets how much? How do you break it up?
Okay. So good question. We'll go back to the blog. And there's something called I'm not connecting to the internet. Never mind. I'm just kidding. No, there's something called an accounting. So as we discussed, a partition action has 4 steps, right? File the lawsuit. There's a right of first refusal. If that's not accepted, there's a sale. Following the sale, the money's deposited in trust with the court, right? And then the money's distributed, right? Through something called an accounting proceeding. So what is an accounting? Here we go. So an accounting is where a court looks at each of the parties' credits and debits or offsets and decides how the equity is going to be split. So let's think about our boyfriend, girlfriend who own this house in East Palo Alto, and let's just make the numbers simple. Let's say it's worth $1 million and they bought it for 500, right? And so there's $500,000 in equity. Theoretically, each should get 250, right? But our ex-boyfriend has been paying the mortgage every month, but all of it, right? So he has a right to an offset for any amount paid above his ownership interest. So for example, let's say his mortgage was $2,000 a month, right? And he pays $2,000 a month, right? So he's paying $1,000 a month more than he's required to as a co-owner, right? So he has a right to $1,000 times 12 times however much, however long he's been there, right? As, you know, a claim for contribution, right? Now there's other claims that she may have. Maybe she put in $100,000 to buy the house and he put in 50,000, right? So she has her counterclaims, right? So the accounting at the end, it's just, you know, accounting, right? It's just working out. Okay, you get this much, she gets that much. That's it.
So let's say she paid to have a house repainted or the kitchen redone. Now, would they give her the base amount based on what she paid for that, or what the appreciated value 10 years later is?
She would, here you go. She would get the amount that was actually expended. So she's not going to be entitled to the increased value in the property resulting from the improvements, but the actual improvements themselves, I think, are clearly compensable.
No depreciation.
You know, that's a really interesting question on depreciation. I mean, because so let's take a different version of that, right? Let's say our boyfriend and girlfriend are living in this house in East Palo Alto. But because she's not living there, she doesn't claim it on her taxes, but he claims 100% of the mortgage interest deduction on his taxes, right? Like, how does that work out? Like, and I think it's a really like novel question as to depreciation, especially in a tax situation. And this is the part of the presentation where I say, I don't give tax advice. So you should definitely discuss that with a qualified CPA, but you know, I don't know that there's any guidance from the courts or the law on that question. It's a very intellectually curious for me, but I don't know that I've actually ever seen it litigated to that. I've never seen anybody make that sort of claim. Yeah, it's interesting. Yes, right here in front. Oh, not you. You. So it's interesting. So let's talk about what courts have found to be a waiver, right? So if we go back to our presentation, okay. So what would a court determine to be a waiver? So here's a common example. Mom wants, and this used to be an issue much more a couple of years ago when the federal government wanted you to show no assets in order to qualify for supplemental income programs, right? So they'd be like, well, you can't get Medicare unless you're broke and you own this house, and so you're not broke, and so you can't qualify. So what mom would do is she would deed it to son and daughter with a life estate. And so she's like, well, I don't own this house, I just have a life estate. Right? So I'm broke, so I qualify. Right? And so then what, you know, son will do is say, well, let's partition it because I own it. Well, the life estate is a waiver of the right to partition until mom no longer owns that life estate. Right? So mom can stay in the house until she's done. And then there may be rights to partition then, but not until then. Right? So that's an example. Yes, it could be an LLC operating agreement. It could be in a written contract. So I have actually seen people execute not prenup agreements, but something called a tenancy in common agreement, which is kind of like a prenup for unmarried people. So I literally saw one like last week and I was shocked. I was like, wow, this, you had like this whole thing. Now, it didn't mention partition or waiver the right to partition. It could have, but they decided to use LegalZoom because they don't need lawyers. So now they have a very interesting situation on their hands, but nevertheless, that's where you would see it.
Second question is, if somebody is presented with this partition, do they have any recourse?
They have the right of first refusal. They can, they can agree to sell. They can try to get a lawyer who can say, well, here's this defense of waiver somehow, somewhere. So yeah, I mean, I generally don't take defense cases because I don't know that I add that much value, but I have a case right now where a client and her ex, they executed like a trust agreement for the property that he was on title, but only holding it in trust. So he basically admitted he's not an owner, and then he tried to partition the property. And I'm like, he kind of admitted he wasn't, he was just holding it in trust. Anyways, so that's what I've seen. So there's, it's funny because like people use, online forms, I all over the place, right? And then they execute them or they change them because they don't need lawyers because they're so smart. So, and then they end up talking to me, right? And it's a whole other situation. So I see all sorts of weird stuff that people just come up with on their own. Yes, you, sir.
So after they don't exercise their first right of refusal, and the judge then dictates that the house has to be sold, what enforcement is there to make that?
How so?
How does it
like-
make the
like-
house be sold?
What would prevent the house from being sold?
The person staying in the house doesn't want it sold, so they take their time listing it, they take their time
Ah.
making it ready, they take.
Ah.
their time- How do you pass that?
Yeah, excellent question. Haha, you have a order for sale, but I am not going to sign the deed. I am not going to sign the escrow instructions. You
Or
know,
not even allow it to show, or I'm gonna say it's appointment only on midnight.
well, yeah. So, one, if they're preventing the court appointed somebody called a partition referee or realtor from accessing the property, then they would be in contempt of court because they are preventing the court from effectuating its orders with respect to the subject matter litigation. And I'm actually involved in one of those right now. So they get to go to jail for preventing the realtor from doing their business. This is what they get. Otherwise, there's something in the law called an elysor. What's an elysor? It means that if somebody will not cooperate with a court order to effectuate transfer, then the court can appoint somebody to sign legal documents on their behalf. So the partition referee can sign the listing agreement, the escrow instructions, the deed transferring the property with court confirmation, right? It's all done the right way. But it's like, we don't need your signature. This has been sold and you are no longer part of the equation. You're gonna get your money. That's it. The way I like to think about it is kind of when you have two kids and they're fighting over a toy, you just come in and say, you don't get to play with that toy anymore. Neither one of you gets to play with that toy. And the judge comes in and says, you don't get to make decisions about that house anymore. I'm making the decisions. That's it. Right? So that's kind of what happens in a partition.
I know this is the family law, the aspect of it, but does an elysor apply in divorce as well? Anyone that might not be your family?
Yeah, I don't so it's interesting. I don't know why it wouldn't. But honestly, I just don't have that much family law experience. So I stay in my little sandbox, I stay in my lane. I don't try to sell office buildings in San Francisco or farmland in Stockton. I just stay in my lane. Yeah. Yes, ma'am.
So you're speaking back, so how do you get in front of it or writing recommendations for someone who considering buying with a friend, or they're setting up a trust, and when parents pass, the kids are getting it, what would be implemented to avoid using your services?
Yeah. I mean, so you just say, you know, I think the best thing you can say, honestly, because you can't give legal advice, right? Is you say, listen, you know, you should really think about talking to a lawyer, right? I think that's it, you know, and people kind of make that choice all the time. I mean, I'll have people who call me and they'll be like, well, I'm doing this partition. I just want to ask you this one question. And I'm like, yeah, like, I don't do that, you know, like, because there's so many other ways. There's like, you know, this is actually the perfect example. You all have some really good questions. You stumped the lawyer. You won the game. You won stump the lawyer. And there's so many things out there, and there's so many weird things in the law and just in courts that, like, you know, it's just better to not get involved, to say, listen, talk to a lawyer, figure it out. And if they don't want to, you know, that's their choice. I mean, I don't think partitions are particularly common. You know, it's probably, my estimation is 0.03% of all real estate sales in California. So it's a very small percentage, right? But you know, I don't know. There's just like it happens. There's stuff out there. Yeah. I don't know if that's satisfying. Yes, you ma'am. You know, at my general take is that they can figure that out on their own. So I just generally push for the property to be sold. There is not, interestingly, a time in the law. So the law was updated recently in 2022. It took effect January this year to provide for this right of first refusal. It's a brand new thing, didn't exist. And I actually know the people who were involved with writing it, and they've never heard of a partition before they enacted this law. And so you could probably expect it's worked out about how you would expect from there. And there's some complications, things aren't clear. You know, do you have to disclose it? How do you effectuate that right of first refusal in court? Who, you know, is there a procedure for that? How are they supposed to do that? Who's supposed to do it? At what point? Nobody knows. And the law is totally clear as mud. So I just say, listen, if you want to effectuate it, that's your right. I'm just going to push forward with partition, you know? And if you effectuate your rights, that's cool. It's on, you know, there's something called the maxims of the law. I think it's like Civil Code section 1651. And it basically says every person is responsible for asserting their rights. So that's on you. You assert your rights and I'll deal with it when it comes. Yeah. Yes, you in the back.
So you mentioned. Do you do anything throughout the process to negotiate with the user brother, and how do you do it?
Yeah, in fact, we negotiate from the beginning. So one of the things that we serve in our complaint packet, so you know, when you file a lawsuit, there's a complaint, you have to serve what's called a summons. In Santa Clara County, there is a case management conference, and I think there's a civil ADR sheet that you have to serve. So it ends up being this packet of like several different things. So one of the things that we put on top of that is a letter to loser brother that says, hey, listen, this is the cheapest, easiest, best time for you to settle. And we are going to start incurring more and more attorney's fees. And so take notice that, like, the longer you want to mess around, like, it's going to happen and it's going to be more expensive for you and it's going to be worse for you. So like, why don't you work with us? Right. And please contact me if you would like to resolve this informally. So yeah, in fact, we start from like literally the day the complaint is served. With the complaint is, let's figure this out. Right. Sometimes people will say to me, well, why? I want to write a letter. Can you just write a letter for me? And I say, I will not. And here's why I don't write letters. The reason I don't write letters is because there's no obligation to respond to a letter. They just throw it in the trash. Okay, this lawyer writes a letter, forget you. The difference with a lawsuit is there are legal consequences to not responding to that lawsuit, right? And every day after that lawsuit is filed, you're getting one step closer to the end of that lawsuit. Whereas you send a letter, there's nothing that happens if you don't respond. You're not getting closer to anything. You're just wasting time. So I don't do that. I file lawsuits, attach a nice letter. It says, please work with us. We prefer to do it the easy way, but you know, we're happy to do it the hard way. Yeah. Yes, you, sir.
Back to me again.
Uh-oh.
She has a really good question, and I interpreted what she said a different way. I think the question I thought she was asking is, if I was gonna do a deal with best friend, we're gonna buy a vacation home.
Oh,
What can I do prior to buying that to minimize my chance to have to do a partition action?
yeah. So I think that,
Is that what
yeah.
you're asking?
So what, yeah, I mean, talk to a lawyer about, something called the tenancy in common agreement. I know some lawyers, they like to draft these. Happy to refer you to them. I don't handle them personally.
Why would that be a waiver? You mentioned for the tenancy of common, would be one of the reasons for a waiver.
Well, because you would put in writing that you waive the right to partition as part of the agreement
Okay.
prior to purchasing the property. So it's a contract and you just insert that provision in there. Yeah, yeah. Anybody else?
Like the realtor, if, like, does the courts have any say on who-
So the court decides. All I can do is make recommendations, right? So I say to the judge, hey, listen, why don't we use this realtor? And my practice, look, you're all, as realtors, you're all fiduciaries for your clients, right? As a lawyer, I'm a fiduciary for my client. So when I have one of these suits, all that I do is I say to my client, who do you want to use as your realtor? Right? And they say, well, you know, this nice lady referred you to me, so let's use her. And I say, terrific, right? I don't try to steer them anyway. I don't try to give them preferences. Whatever they want, I just say, cool, right? Because that's me trying to do what they think is in their best interest, right? The court makes that decision ultimately. But you know, generally a lot of these cases, there's not a lot of competition on that front. So at least from what I've seen. Yes.
30 minutes or 1 hour free for taking them on?
Good question. Good question. So I charge $250 for a half-hour consultation, unless they're referred by a realtor. Then I do free consultations, but they have to say I was referred by this realtor. So it's, you know, a nice benefit for you. You say, listen, just because you know me, you get this consultation with this lawyer. So we do that. Yep. Anybody else? No? All right. Well, thank you very much for listening, and I'm happy to talk with anybody else after who wants to. Thank you.